Bruce back at it again with us. I am clicking on the button if it popped up on yours as well that this meeting will be recorded. NorCal LERA, as all the other LERAs, we are a forum for discussing emerging trends and having fellowship amongst folks from union, management, neutral, all across the board. And we just, again, as Narita said earlier, encourage you to reach out to your local chapter. And you're always welcome with us, of course, too. I'd like to introduce Bruce Harland. He is managing partner at Weinberg, Roger and Rosenfeld. He is a graduate of Rutgers Law School at the University of San Francisco. He is a regular speaker in the field of labor and employment law. He specializes in the representation of healthcare unions, and he has tenure as an organizer. We also have Bob Spagat with us, who is a senior vice president and assistant general counsel at Kaiser Permanente. Bob is a graduate of both Berkeley Law School, Middlebury College, and Stanford University. Bob heads the labor and employment law practice at Kaiser, and he also is over one of the most complex labor environments in the entire United States. So I turn it over to Bruce and Bob, and thank you again so much for making the time yet again for NorCal LERA on this very important update.
Thanks very much, Lisa. Let me start by saying I think I speak for both Bruce and me in saying how delighted we are to be here with you in the future. You know, looking at what's happened since we last spoke to this group. And maybe I'd like to set the stage a little bit. You know, a year ago when we were speaking to you all, what we talked about what was current at the time, major gains for unions and organizing. That came with an increase in militancy seen in some of the bargaining tables, you know, across the country, increased public approval for unions, the Biden board and general counsel having done a lot to expand the scope of the National Labor Relations Act, rules around union organizing, what constitutes protected concerted activity, the prosecution of unfair labor practice charges, full remedies, all of that. And, you know, shortly, and a lot of speculation as to what would happen in the election and what direction things might go. In the meantime, obviously, you know, Donald Trump was elected president. He ran as a populist from the right. He had support from some labor. I think labor, is probably fair to say, was divided over him, but he definitely had some support from labor. Appointed a labor secretary that was greeted with some amount of approval from labor as well. And he did not go to any much effort to make public what his plans were for the NLRB. So here we are 1 year later, and Bruce, I guess the question maybe you could start in. Okay, years gone by. What do we know now that we didn't know then about what's happening at the NLRB?
Well, I think a year ago, Bob, we were pretty good. I mean, we predicted the future. We predicted that there would be chaos, and there is chaos. You were a little off on your prediction about the East Wing being demolished and turned into a ballroom, but other than that, I think we were kind of on it. Let me just say, by the way, I'm really happy to be here and echo everything that Bob said about participating in this, and it's great to see some familiar names and faces. But yeah, a year ago, I think when we were here, Gwen Wilcox had just been fired from the NLRB. Just a reminder, Gwen Wilcox was the first African-American woman ever to serve as the chair of the NLRB. And at the time she was fired, there were 2 other board members, both white males, and they remained in the job. Since then, there has been no quorum at the NLRB, so nothing has been processed by the NLRB. At the regional level, until the government shut down, you know, the regions were processing charges, they were holding hearings, but when it got to the NLRB, because of no quorum, as a result of Gwen's firing, there's just nothing has been moving along at the NLRB. So really no change in the case law at the NLRB because the NLRB has issued no cases. What Trump and his administration did do is he appointed an acting general counsel of the NLRB, William Cowan from Los Angeles, from the Southern California region. And I'm sure Tom Lenz could talk about him in detail. He did nominate in the spring a permanent general counsel, a person named Crystal Carey from Morgan Lewis, represents a lot of big companies and corporations who are defending themselves before the NLRB right now. He also nominated 2 board members, somebody named Scott Mayer, who's the chief counsel of Boeing, and James Murphy, who's a kind of a career NLRB attorney out of Washington, D.C. Crystal Carey, had a little bit of a hiccup with Senator Josh Hawley, but I think they worked it out. And she flew through and got reported out of committee and is waiting for a full Senate confirmation. James Murphy, he flew through as a career attorney, wasn't very that, it's not that controversial. And then Scott Mayer, who is the chief counsel of Boeing, had a kind of a disastrous Senate confirmation committee hearing. If for those who are bored on a weekend and have nothing better to do, I encourage you to watch that committee hearing on YouTube. And because he's involved obviously with Boeing, and Boeing is involved in negotiations and a strike with Boeing workers in Missouri. And so Josh Hawley really pressed him hard on those issues. And at one point, Hawley asked him, what does he think is a fair deal for workers? And Mayer said the concept of fairness is an elusive one. And it kind of went downhill from there. So he has not been reported out of the committee. Last we know, he's auditing a philosophy class at a community college trying to determine what fairness is. So he's unlikely to be confirmed because he's not even going to get to the Senate, which is going to leave us really with 2 board members and, again, a lack of a quorum. So it's not even clear that we're going to have a functioning board in the year 2026 if James Murphy gets confirmed and Crystal Carey also gets confirmed as the general counsel. The big thing I think, though, to note is what William Cowan has done as the acting general counsel, because he kind of went to town immediately. And we talked about this last year, that we thought that this would be something that he would do pretty much immediately, or whoever was placed in that position as acting general counsel. And the big thing that he did was issue a general counsel memo that rescinded all of his predecessors' general counsel memos, or for the most part, all of them. And I just want to go through a couple of them for folks, because I think this is kind of the biggest deal of 2025, and it kind of gives you a sense of the priorities of the administration and the NLRB. It's not law, but it gives you the sense of how the general counsel's office sees the National Labor Relations Act, how it interprets the National Labor Relations Act, and kind of its program and priorities for the National Labor Relations Act. So for example, there's been a lot of talk always about the National Labor Relations Board being behind the times. And so one of the things that Jennifer Abruzzo did was issue a general counsel memo regarding electronic monitoring and algorithmic management of employees. And where it interfered with Section 7 rights, you know, under her leadership, the general counsel's office was going to look for cases and they were going to prosecute it. Cowan eliminated that memo. And I want to read to you what one law firm that represents management said about this. They said that this rescission of this memo provides, quote, more room for employers to productively utilize surveillance and algorithmic management tools for legitimate purposes. That's a fancy way of saying it'll, you know, go ahead and spy on your employees now and watch what they do, especially when it comes to union activity. So that's just one. You know, he eliminated the memo regarding full remedies for all victims of unlawful conduct. He got rid of the memo regarding non-compete agreements, especially where employers would enter into non-compete or stay or pay provisions, finding that, you know, signaling that he doesn't think that that's a problem with respect to Section 7 rights. He rescinded the memo regarding ensuring rights and remedies for immigrant workers under the NLRA. And again, here's what another management firm says about that. They say that memo really shows that the acting general counsel appears, quote, appears to be aligning the board's immigration policy with the current administration, close quote. Oh boy, that's scary. So that's another big one. He eliminated the memo regarding CEMEX. He eliminated the memo regarding seeking more injunctions. He eliminated the memo about cross-agency participation, which is obviously going to result in some delay and confusion in terms of coordination of board enforcement. There was a memo about needing to process these cases more efficiently. He eliminated that memo. And here's another management firm's take on that. They say the result of this is that, quote, it's going to be slower case resolutions and enforcement and less pressure on respondents. You know, unions can be respondents, but what they're really talking about is less pressure on employers to comply with board orders. So he took a number of steps in his capacity as the acting general counsel to really signal, I think, where the board and the administration want to go. And once we get a functioning board, I think for unions and workers, it's going to be scary times. I don't know how you feel about for employers.
Yeah, I mean, I guess the way I would frame it is that under Jennifer Abruzzo, you know, I mean, she was very aggressive in expanding board law, and you know, this was kind of in one fell swoop, kind of, for lack of a better way to describe it, resetting the clock to what it was before she came on board. You know, some of the things that under the Cowan general counsel memos, so he issued a memo on full remedies, and you know, in my mind, struck a more appropriate balance. This is the prosecutorial, you know, these are memos of how they're going to prosecute cases. And so, whereas her memo was, we're only going to settle for full and total relief, his memo was, you know, full relief is the goal, but let's be realistic about settling cases. You know, if we're only going to settle cases for the total amount you could get if you won your case, then we're not going to settle a lot of cases. So I couldn't disagree with you that it was quite quite a reversal of the prosecutorial policies that were implemented under Ms. Abruzzo and as part of the overall Biden board approach. And it certainly could be viewed as signaling much bigger change than what I would say what I would kind of characterize as a move back to what the status quo was before the Biden board. I mean, I think what you're saying is it's signaling the pendulum swinging, well past 6 o'clock to something much farther to the right of that. And I couldn't, if I was placing a bet, I don't think I would disagree much with that. I think it remains to be seen. I think it's interesting that, and the reason I say that is because he is a populist, coming from the right, and kind of speaking on behalf in his own framing of certainly aspects of the working class. I don't want to opine on whether that's in fact the case or not, but certainly that's part of his narrative. And so it raises a question in my mind, why has it taken so long? So he shut the board down basically by firing Wilcox and just kind of holding pat while that's all being litigated. So what's really the strategy there? Is he just too busy to fill the board with people who are going to move the board to the right? Is he running out the clock while he's working on other things? Like what, I think we don't quite know.
No, I agree with that,
Yeah.
Bob. I mean, I think the last time we were here, we tried to speculate about it. And one of the themes that we did talk about is, he revels in chaos. And that's kind of what he's created here. But yeah, I don't see, and I'd be interested in what you think about this. I mean, I don't see a master plan for the NLRB, other than weaken it and create chaos. Nobody's trying to reshape it, change it, like statutorily. I mean,
Right.
Cowan.
So someone's trying to change it. It's Elon Musk, I think.
Right.
And that, not trying to make a joke. I mean, and I wonder if this is part of the strategy to just sort of wait it out and see if the NLRA after, well, not quite 100 years, but
Close
89
to, yeah.
years, is going to be deemed unconstitutional. And is that part of the reason why it would seem that these appointments are being slow walked? At least it seems to me that they're being slow walked.
Yeah, that may very well be so. I mean, we didn't talk about the other stuff that really happened in 2025, and it's less about board cases and more about what's happening in the courts, and
Right.
so, we've got Wilcox's case that's in the Court of Appeals for the district court. She sought kind of an emergency expedited hearing from the Supreme Court on that in September, and they said they wouldn't look at that, but they were going to look at a companion case involving another agency. And then you have, the SpaceX case that's in the Fifth Circuit, and that's, if you are a worker in Texas, Louisiana, Mississippi, and your employer engages in an unfair labor practice charge because of that case, now you run into a district court and you're going to get an injunction against the NLRB doing anything. So that's playing out in the Fifth Circuit right now, and that's going to head up to the Supreme Court as you mentioned, and that's going to test the constitutionality of the act. Then you've got the Thrive case, the one that deals with the direct and foreseeable pecuniary harms, the remedies case, that expanded the traditional make whole remedies, and there's a circuit split there. the Ninth Circuit just came out in favor of the Thrive remedies in a case involving the Stationary Engineers Local 39 and Macy's. And then you have a split in the Fifth and the Sixth Circuit going the different way. So that's definitely, being teed up to go to the Supreme Court. And there's issues around Thrive. There's issues around the right to the trial by jury and all that kind of stuff.
So what do you think about so in SpaceX, one of the key arguments is you've got, the NLRB is not so it's an executive it's an agency. It's not an Article I court. It's an executive agency. And yet the board members don't serve at the pleasure of the president. They can only be removed for neglect of duty or malfeasance in office. That's what the NLRA says. ALJs can only be removed from good cause. Do you think that's vulnerable to a constitutional challenge?
Yeah, I'll give you a lawyer answer because you sometimes give me lawyer answers when we talk. So I'm not going to answer the question directly because I don't think it matters about what the law is, honestly. I think you just have to count, and you count the number of Republican appointed, specifically Trump appointed members of the Supreme Court, and these cases get up there. I think we're going to lose. The labor movement's going to lose. Workers are going to lose. I think employers are going to lose too, because there's a real likelihood that they find that the NLRA is unconstitutional, and or parts of it are unconstitutional, and that ALJs and board members have to serve at the pleasure of the president. And I don't think that benefits anybody in our society, employers, workers, or unions. I think it's going to be bad for that to happen.
I mean, it raises the larger question. So Congress, I mean, those standards were part of the statute, so Congress enacted it. The then president signed it. And I think if I was arguing the case, the question I'd be asking myself is, well, okay, can a Congress and a president bind a future president in this way? And I'm not sure what the answer is, but if I think about labor policy, I would say it doesn't strike me as a good idea that the board and the ALGs are serving at the pleasure of whoever's the incumbent in office. I think that was clearly done on purpose,
Yeah.
with the idea that that it's a highly political area of life in our capitalist system, and to try and depoliticize it and have rules that are predictable, that can be followed. And so, that to me is a significant concern. I don't know. I don't know how that will end up being briefed, or what the Supreme Court will say about it. It goes beyond labor policy, but it just strikes me as, and this is kind of maybe a dialed back way of saying what you were already saying. It creates uncertainty. Whether it creates chaos, I don't know, but it certainly creates uncertainty in an area where certainty would I think support the public policies of the National Labor Relations Act, to have labor peace and to have uninterrupted flow of goods and services in the economy.
Mm-hmm. Yeah, I mean, to be fair too, it's there's not unanimity among labor unions, or among, I think you would say the same probably about the management side, or companies or employers. There's not unanimity related to whether or not it's good or bad to have a federal labor law. I mean, I think, speaking from the union side, there are unionists that would say, yeah, we don't want to be burdened by some of the restrictions in the National Labor Relations Act, like secondary boycotting.
Yeah, so I was just thinking that, yeah.
Secondary picketing and those kind of things. And we don't get much from the National Labor Relations Act except for delay and frustration, et cetera, and there are certainly trade unionists who would not shed a tear if the act was torn up and they were just allowed to do what
Yeah,
they
it depends on what replaces it.
well, that's a good point. I mean, that's a good point because I think that's the other kind of theme of 2025, which is, you're seeing a lot of these state legislatures passing laws trying to address issues in their states. And so I agree. I think this is what you're saying, but I agree with you that if the National Labor Relations Act was deemed unconstitutional or was just ripped up and thrown away, for kind of sake of argument, something is going to replace it. And I assume something is going to replace it at the federal level. And it just depends on who's in power. And if Trump and his crew is in power, then it's going to look really, really bad. If the Democrats are in power, and it's going to look better.
I
But
have news for you. It's probably going to be a divided Congress. So,
no, sure, you got to pass something, right? And so if you don't pass
so I
anything,
don't, yeah, right. What are we
if you don't
going to
pass
actually be
any,
able to pass?
yeah, if you don't pass anything, then some of these laws that have been passed in a number of states, including California, like AB 288, which is the law that allows PERB to enforce the NLRA under, various conditions. Basically, if the NLRB is not functioning, those are kind of very progressive, good laws, but that's in California. I mean, if you live in Mississippi or you live in Tennessee or you live in, Texas, you're probably not going to get a law like that. You're going to have a country where there are certain states that have very strong, robust labor protections, and there are going to be other states that have little to none. So I
On that, that will exacerbate, the problem of companies moving to states that are easier to operate in.
sure, yeah.
I mean, that already happens, but for sure that doesn't help. And I would say, I mean, I certainly don't speak on behalf of employers by any means or the management bar. But at least in my view, um, it's important to have a federal standard for labor law and not have it be kind of a patchwork quilt of state and local laws. We have that with a lot of, wage and hour law and other areas of employment law. And it's difficult and expensive and complicated to manage all that. And so for that reason, and probably just to keep the playing field, again, predictable, which is so critical at the level of labor relations. It's hard for me to see, state laws being the answer to the problem.
Let me ask you, I mean, in terms of, let's say that the NLRA is declared unconstitutional, or, that either the Republicans or the Democrats want to change it in some way. I mean, do you think that that is politically viable? I mean, do you think there's enough there to do that?
Um, I'm not that great at predicting what flies in this country, to be honest. I live in San Francisco, so like the last time I saw a Republican was kind of a while ago. Um, Joking, of course, but only sort of. Um, you know, I don't think it's out of the, I mean, I don't think it's out of the question. I think you said something along these lines earlier that the Supreme Court, kind of makes this decision. I mean, their understanding of precedent, and is hard for me to quite candidly predict.
Mhm.
Um, And so, and then what does that mean? Does that mean, we're going to have an NLRA, but the president can fire the board? I mean, as it is, that, you have to have Republicans and Democrats, and, I mean, the statute couldn't have been more carefully thought through. Um, so that would be a major, major change, and I think it would, greatly undermine confidence in the system. If board members and ALJs are kind of can just be kind of thrown out with the new administration. But that would be, I guess, one possible outcome. I don't know if it would result in, okay, the NLRA is just kind of off the boards and we're going to start from scratch. I wouldn't have any confidence that Congress could pass.
Yeah.
So, I think it would just be kind of a free-for-all.
Yeah, I mean, that PRO Act has been hanging around for a while in the halls of Congress, and that's probably unlikely to pass. Although, I mean, I think it would go a long way in fixing, from the union's perspective, a lot of issues with the current NLRA deficiencies. But yeah, I find it hard to believe unless in 3 years Trump and the Republicans are totally removed, and the Democrats win both houses and the presidency, and then there's enough Democrats really to vote for something like that, and a president to sign. I mean, the other thing is there's a number of kind of people, there's a lot of folks, academics, practitioners, trying to think about and reimagine, like how could you fix the NLRA? How can you fix the NLRB? And one of the people thinking about this is Roger King, that I'm sure some of you know. I mean, he and a couple of academics have thought about, what if we just like reimagine what the structure of the NLRB looks like, so that we could kind of deal not only with these constitutional challenges to it, but also, maybe get some stuff done there. And one of the things they came up with is, why don't we just reconfigure the whole NLRB, replace the 5-member board with a new 6-member board, and so that 2 of those 6 are Republicans, 2 of the 6 are Democrats, and the remaining 2 are independents. Now, I don't know what independents mean. Maybe they're Democratic Socialists of America. I don't know, but it'd be 2 and 2 and 2, and then the board under this kind of scheme would lose its rulemaking authority. It wouldn't have the ability to make rules. It'd basically just be kind of like an appellate review level of administrative law judge decisions. And then it would, and under this scheme, it would require at least 4 of the 6 board members to rule in favor of overruling a precedent. So I think what they're trying to do, I mean, I personally have some issues with it, but I think what they're trying to do is come up with a scheme that kind of addresses the points you were making, predictability, dealing with any constitutional challenges, and also kind of expanding the board with more viewpoints, etc. I don't know. What do you think about something like that?
The first thing I want to know is who's deciding who the independents are going to be on that.
Well, it would be the president. That's why I said maybe they would be Democratic Socialists of America. I don't know. Let's hope so. But no, you're absolutely right. That's kind of That's kind of a fuzzy word, isn't it?
Um, yeah, I mean, I think that maybe in some version of America that's a good idea. And we're, we're in the most gridlocked. I mean, we're just in a wildly gridlocked, point in history. Um, and so I'm struggling to see how that is going to solve the problem. Would it be better than what we've got? Um, I don't know. I'd have to kind of give that some thought. Um, but I guess I mean, because I would view that as a way that you could almost never overturn anything. So
Yeah, I
maybe
mean,
that's a
well,
good thing, but
sure.
um,
70-year-old precedents,
right. I mean, at some point
maybe
you're going to
shouldn't be
have to allow
overturned.
that as the economy, you know, changes with much greater speed than it did 70 years ago, that there's going to have to be adaptability. How you get that, I don't really have the answer, but we'll see if some. I think the first thing that would have to happen is the Supreme Court would weigh in, and if they declare this unconstitutional, I think it's probably the stakes are probably bigger than labor law, frankly, at that point. Um, so, hang on, we got a question here.
Yeah, Gina is very
Was it Collins?
perceptive.
Hello, Gina. Well, the FEC or yeah, permanent gridlock. Well, so that would be my concern that you could have
Well,
fairly
yeah,
permanent gridlock. Yeah.
I think the thinking is that the Republicans and the Democrats appointed members would probably never vote the same way, and you'd avoid the gridlock that way. You know, there's there's kind of a challenge to this idea, and it comes from a practitioner on the union side who's now teaching law school, I think. But he's come up with an idea, and he says, that it doesn't make much sense what King and others are thinking about. I mean, he's come up with this idea. You just get rid of the labor board totally. There's a single director of the National Labor Relations Board that's appointed by the President of the United States, and that would be a person that would set the policy of the labor board. But to adjudicate cases, to get around these constitutional arguments, the president or Congress would create a specific labor court, a labor circuit, like bankruptcy court, and the president, with confirmation of the Senate, would appoint judges to the labor court. They would they would have life tenure like district court judges, and it would be a specialized court where all labor issues just go to that, and they would have the full powers of district courts, etc. And that, is a way in his thinking to address again, that consistency, stability. You couldn't go and form shop, if you're Elon Musk and SpaceX, and you get an unfair labor practice in one of your facilities in California here, but you're headquartered in Texas, you could run to Texas. Currently, you could run to Texas and file an appeal in the Fifth Circuit there, and that's what he did with SpaceX. So it's kind of deals with the issue of forum shopping as well. What are your thoughts about that?
So some countries have that,
Yeah,
certainly. Um, I mean, I think that would probably be worth a look. I mean, if we were actually, kind of rewriting the law from scratch, I think you would probably want to consider something like that. Um, and ultimately, if you're doing a constitutional challenge, ultimately it would find its way up to the Supreme Court potentially. But short of that, to have a specialty court handling it, um, I think it's worth looking at. I mean, now you're kind of trading when the NLRB is working, you've got kind of the split between Republicans and Democrats and the balance going to the party with the that holds the presidency. Um, so is this having life appointed judges, or it could still be like 10-year appointments or 20-year appointments, whatever it is. Is that an improvement? I don't know. I'd have to kind of think that one through. I mean, when the board is functioning, you've got at least the dialogue between the board members. And I don't actually know the statistics about how often they split. I don't know that it happens all the time, but certainly, like with the courts, you see it happening in the controversial cases. You see them kind of dividing on partisan lines.
Mhm. Mhm.
Yeah. How about Thrive remedies in that case? What do you think about the argument that this should really be, if you're seeking full remedies, you should be in court and have a right to a jury?
Again, I think just putting aside the legal arguments, and I think the Sixth Circuit just came out with a decision. There's a really good dissent in that case, and folks should read it. But I think just putting aside the legal arguments on Thrive, if this gets to the Supreme Court, then I think that's problematic for the labor movement and Thrive in general. I don't think it's going to exist beyond the Supreme Court. I will say though, again, there's I think actually I take that back. I think most people on the labor side, want to try to protect Thrive. They don't want to have to do jury trials at every NLRB hearing, where the NLRB issues a complaint. But I mean, I don't know. Maybe that's a really good organizing opportunity for the unions as well to have a CEO or a manager in front of a jury, explain, come and have to testify about the unfair labor practices that their company committed. I don't know. I mean, uh, I guess I'd have to think whether that's a good thing or a bad thing. I certainly think that there's an opportunity there to put a bigger light on some of the more um, nefarious employers in the world. Not all employers are bad. I could agree with that, but there are some really bad employers that make the good ones, bring down the good ones. And so, gosh, having a jury look at some of that stuff, I don't know. Um, what are your thoughts?
Um, I think it's harder to get to a jury than it is to get to a hearing at the NLRB. Just as a
Yeah.
practical matter, and time consuming and expensive.
Yeah.
Um, and I think the courts are probably, pretty overwhelmed with their dockets. I mean, or at least pretty busy with their dockets right now. Um, so it doesn't seem super workable to me as a
Yeah.
remedy. Um, would employers be afraid to go in front of juries? Could be in some, some venues, this goes back to your Fifth Circuit, Ninth Circuit, blue state, red state issue. Um, but it doesn't seem very practical, I guess, is my overarching feeling. Let me change the subject a little bit and ask, um, what are your thoughts on how the labor movement is meeting this moment? So there's, kind of stalled out NLRB, um, a lot of devastation in public employment at the federal level, certainly.
Yeah.
Um, and all the uncertainty that goes with all of that. What are your thoughts on, is the labor movement changing to, meet the moment?
Yeah, I think that's a really good question. I don't know if it's so much changing, but the only good thing about Trump and the folks around him and his administration is it's created a moment in which the labor movement and quite frankly, other citizen groups are beginning to realize that they have some muscle that may have atrophied and now they're exercising it. I mean, and I think that's always built into the DNA of the labor movement, but it's something that is now um, being exercised in a way that we haven't seen in a while. And so, you look at, I mean, the labor movement, along with other groups, are kind of at the forefront of challenging a lot of these executive orders that Trump has issued, or a lot of the terminations, especially at the federal level. Labor movement was very involved with other groups around the SNAP benefits, that kind of stuff. So like from a legal perspective, yeah,
Immigration, yeah.
immigration, huge, so from kind of a legal perspective, they're putting their resources into that and helping with that. But then, you look at the No Kings events. That wasn't all the labor movement, but that was a lot of participation by labor. Um, you look at just the politics and the elections that happened a couple of days ago, whether it's Prop 50 in California, which was backed by labor, or the mayoral election in New York City, and so I think that the one positive thing, if I could find something positive that has come out of Donald Trump and his crew, is that it's reminded labor that they do have muscle, and it's reminded ordinary working people that they do have a muscle, and they're starting to exercise that. And I think you're going to see that grow, and and I think that's a positive thing for the country. I don't know what your thoughts are about that, or what I'm interested in actually from the employer side, because I think that I think there's a lot of danger. Obviously, I think there's a lot of danger in the policies of this administration on many levels. But if you just zero in on labor, I think for all the reasons you kind of mentioned earlier about the lack of predictability, et cetera. The one thing you notice is that employers, you didn't see any employers or management side counsel, I don't recall of any, that stood up and said, why are you firing the first African American woman to be the chair, who's the chair of the labor board? That's not good for the National Labor Relations Board. There was just a deafening silence about that. So I think that, didn't the Supreme Court say corporations are citizens too, right? It could, why aren't
Corporations are people.
people, right? Yeah,
Yes,
people, right?
yes.
I think there are employers who, as I said, are good employers who get along and cooperate with the unions that represent their workers. Where are their voices? And I think that's a problem.
It's a great observation. It's a great question. And here again, I'm not really speaking for, my employer or any employer. I think, but I think,
You're being recorded, Bob, so be
I know,
careful.
but I have some speculation.
Yeah,
I mean, I think there's a good deal of fear,
sure.
around the retaliation, that can occur. And so, where you see it playing out, not in corporate America, but, with the universities and the, and with the law firms, I mean, I was pretty astonished to see how many law firms just sort of wilted in front of the kind of bullying from the Trump administration that is frankly shameful. I mean, law firms should be doing pro bono work and representing disadvantaged viewpoints and people and some really stood up to it and some decidedly did not, and universities, but it's a calculus that they're going through. They want to carry out their missions and they have to think carefully about when to fight and how to fight uh, and so I think from a company point of view, if your heart is in the place of I don't support what's happening, you've got a lot of calculations to make about how far can you go if you're a publicly held company. What do you owe your shareholders? What do you owe your, you know? So I think that that's a fancy way of saying, to a great extent, the bullying was effective.
Yeah. A classic example of an 8A1 violation by the president, threatening,
Yeah.
intimidating, coercing.
I don't even think that one rates. I'm thinking about this 10% reduction that the transportation officials are saying. We're going to cut back on traffic at 40 airports. So I'm working on the assumption that they're working, that the Trump administration has signed off on this. So if you think about this as a management instigated, partial work stoppage, I mean,
Yeah,
what's up with that?
it's a lockout. Yeah, we should
Or
do something
something.
about that. Yeah, no, I mean, just to kind of sum up
A
in terms
lockout of
of,
unpaid workers, by the way, that's the worst kind of lockout.
yeah, no, definitely. And I think to that point, I mean, the longer that the shutdown goes on, I think you're going to have a lot of angry people. And I think you're going to have, uh, like, for example, in terms of the board, if you go on their website today, because of the shutdown, you can't access a single thing. You
You
can't
can't file a
access
charge. You can't
can't
do
file a
anything.
charge.
Yeah.
You can't
Yeah.
look up cases. You don't know. You can't look at the Know Your Rights flyer that they have.
Yeah.
You can't know what is and what isn't an unfair labor practice charge if you're a business trying to figure out something. It's totally shut down. And I think if the shutdown goes on longer, and even if the shutdown doesn't, but the board is effectively, not doing anything, you're going to see more people on the streets. I mean, I was involved in just by way of example, I was involved in a kind of a big election in Southern California that was going to happen in the middle of October. And this involved 1,400 workers at a hospital. And because of the shutdown, they canceled the election. And so we have no idea when the election is going to be rescheduled. First the government has to be reopened, and then it has
Yeah.
to,
Yeah.
then all the NLRB agents who work there have to come back. We don't know if that's a reality or not.
Yeah. Yeah.
And
As it
then,
drags on.
yeah, then it's got to be rescheduled. But there's a lot of workers who don't care about any of that. They just want their union. And um, so I do think that there's just going to be a growing amount of pressure to do something, and workers will do it on their own. Unions will be more aggressive,
Yeah.
and I think that's what we're headed for.
Yeah. Well, it can't last forever. At least so far, it hasn't lasted forever. Um, maybe we'll come back next year and see if the lockout if we can report that it ended.
All right, sounds
Well,
good.
So I think we're
Bob,
probably done what we can do. Yeah, I don't know if there are any questions with the last
yeah,
couple.
Bob and Bruce, this has been absolutely fantastic, and love the dialogue back and forth. That you guys are just fascinating to watch, and just you covered so much in such a short amount of time. We have 5 minutes left for questions or any other thoughts or comments. Gina.
Sorry to hog the questions, but I want to take advantage of these two big brains. So what do you think of the following scenario? Let's assume that board independence gets crushed under the juggernaut of the unitary executive, just like every other so-called independent agency, but the substance of the NLRA remains intact. Do you think at the end of the day, sort of out there in the world, day to day, that's going to be that much different from what is in place now, which is already a pretty big swing depending on the administration of how the act is enforced, how it's interpreted, etc. In other words, how much of a difference is it going to make at the end of the day?
Yeah, I think that's a fair question, but I think if the President of the United States gets to direct people how they should rule, under the threat of being removed, that if the current president if that's happening under the current administration, I think that emboldens employers, particularly bad employers, to act very bad, and so I do think it would affect the day-to-day stuff. I mean, it's like when Franklin Roosevelt came out and said, after the enactment of the NLRA, that everybody should be in a union. Every worker should be. If I was a worker, I would be in a union or something to that effect. And that emboldened organizing, because the President of the United States endorsed that. And so I do think it has a direct impact on the day-to-day and experience of workers and in workplaces.
And I would say this too, in a Republican administration, there's still only so far things swing. From an employer side, from advising employers, it's not like in a typical Republican administration, okay, now it's a free for all. The pendulum swings, but it's swinging between, I don't know, like 4 and 8. If you're under the thumb, if you think that your next decision could get you fired, I just think that the potential for mischief and destabilization is pretty great. Thanks for the question. Any other questions? Well, hearing none.
Well, thank you both again. We are absolutely delighted, and I'll take the opportunity to ask you back for next year in advance with hope for the future.
All right. Well, thank you so much.
Thanks for having us.
Thank you, gentlemen.
Yep.
Everybody have a great rest of your day.
Thanks so much.
Bye, everyone.
Thank you.